explain why it will have any evidentiary value under 162 of CRPC, because CRPC does not deal with Evidence Act. So,
Though it
can
does
you
not deal
elaborate
with,
on that?
though the CRPC doesn't deal with.
You yourself say that statement made will not have any evidentiary value. So, CRPC is a procedural law, not an evidentiary law. So, how can a section 162 under CRPC grant or any statement made before a police officer a valid statement which can be acted upon, and that too under such a heinous offense, such a serious offense which has been alleged to be have been committed? So, just explain that properly.
Well, Your Lordship, Section 162 basically provides the police the right to acquire to investigate any person accused in any case. So that statement basically, it becomes admissible in court. Once it is
Whatever you are saying is contrary to Section 25 of Evidence Act.
not if it is read with Section 27 of the Evidence Act,
So,
Your
so
Lordship.
you are correct. Section 27 is an exception to Section 25, but that is only limited to the recovery. That you had the knowledge of the particular thing which has been recovered. Everything beyond that cannot be read. So how do you get out of it?
But Your Lordship, it must be understood that it was the statement that was, it was through the investigation that it was that such a, the statements which were given by the accused, Your Lordship, not on arbitrary powers or
But
anything.
where was that statement made, Mr. Counsel?
It was made to
To whom the statement was made?
the NIA.
Exactly. So does the NIA have any special provisions where a statement made to a particular police officer or NIA officer can be admitted or accepted to be true, and bar of Section 25 is not there?
Your Lordship, that's why I mentioned the case, the state of Rajasthan versus Tejaram. It was in that case where it was held by the court that the witness statement does become admissible in court. And it was based on those
Under
kind
what
of.
circumstances? What is the procedure under 162 for a writ statement to be made to be admitted?
162 is basically providing the right for a police officer to hear these what do you call the statements made by the accused, Your Lordship.
Okay, continue.
Okay. So in these circumstances, it can only necessitate the judiciary to investigate deeper. In this case, as stated, there is some value to the statement since it was based on the information given to the police, which under which they were able to apprehend the accused. So during the course of the investigation, both the accused Samir and Monu, had admitted their involvement and revealed that they collected the fake currencies from the third accused, that is Kalu at Mama. It is crucial to note here that extrajudicial confessions do have some evidentiary value as well as that of judicial confessions, and they must not be seen as an inferior category of confession. This was what was held by in another case, State of Rajasthan versus Rajaram in 2003. So, moving further, the call detail records of the accused and Monu also came into the picture. It was also held in a case called Om Prakash versus State of Madhya Pradesh that details that is gathered from mobile phones, be it call records or for tracing locations, becomes very important in these kind of important cases regarding the gravity of the situation, regarding the security of the nation. So, based on these
First, to
evidence,
explain under what circumstances call details can be accepted. What is the procedure to prove call details? Has that procedure been followed or not?
just a moment, Your Lordship. My co-counsel will be dealing with that issue,
Perfect.
the third one.
Co-counsel, just remember to argue on this aspect. Proceed.
Sure, sir.
Thank you, sir. So it was later, through the investigation, it was found out that the money that the two accused had, it was supposed to be delivered to another accused, Peter, once they reach Pulwama. So it is to be noted again that in case Pyara Singh was a state of Punjab, the apex court declared that the law does not require that evidence of an extrajudicial confession should, in all cases, be corroborated. In this case, the statement given by Gaddu Singh and the confession given by accused to show that the stated accused had knowledge about the facts that the notes were, in fact, fake currencies. Therefore, it is submitted that the accused must be held under sections 489B and 489C of the IPC, as they were undoubtedly in the possession of those currency notes, fake currency notes, and the fact that they were transporting it to be delivered to Peter proves that the currency notes were being used. So, if your lordships are satisfied with the first contentions, require permission to move on to the second contention.
Mr. Counsel, kindly elaborate. Whatever you have argued is just based on the statements made by the accused, right? And fake currencies have been recovered, right? So, how do you say that these currencies have been recovered? So, the knowledge of the accused person vis-a-vis the currency cannot be disputed because Section 27 helps you. Rest statement is barred by Section 25, and you have cited certain case laws where it says that extrajudicial confession is admissible. So, what is the law for what is the procedure for accepting extrajudicial confessions? Some conditions would have been given in those judgments. Can you elaborate on circumstances given in those judgments which you were citing?
Again, your lordship, it will be dealt in the third issue by my co-counsel.
All right, proceed on the second.
Much obliged.
Contention.
So the second contention is whether the stated accused are involved in criminal conspiracy. So it is contended that they are involved in criminal conspiracy. It was prima facie clear that the accused Samir and Monu had knowingly processed the high-quality fake currency notes, which will again be dealt with in the next issue as well. So it is to be noted that in order to establish a conspiracy, there should be meeting of minds, which is one of the important essentials. And the prosecution counsel will establish this. So from again, we must infer from the previous issue as well for this. So first, to start with the oral statement given by the prosecution witness
Mr.
number 2,
Counsel, which sections of the IPC deals with conspiracy?
sections 120.
What are the essential ingredients of 120?
So those essentials are stated in sections 120A. One is that the act should be illegal, and the second one is that though the act may not be illegal, there must be an agreement between all the members of the members to commit an act through illegal means.
Okay. So now test the facts of the case on section 120 and establish whether there is a conspiracy or not.
Could you please repeat that, Your Lordship?
I'm just saying, kindly argue that ingredients of section 120 is fulfilled or not in the case. Yes.
Sure, Your Lordship. This I could. The counsel would like to bring your attention to the call detailed records as well. It was found out that all the 4 accused were in contact with one another throughout this process of either carrying the money or with the or with regarding to the bomb blast code, which I will be covering with this issue as well, Your Lordship. So if my permit, I will continue. Your Lordship. So based on the statement given by prosecution witness number 2, Iqbal Khan, he said that he heard the accused Samir and Monu were planning to do something big, and in another instant, he also heard that Kalu saying that India is not a country worth living and it is a country of intolerance. This shows that he had some motive to commit a crime. The police has used the statement in process of investigation as per under section 161 of the CRPC. Moreover, Samir, when he confessed, he admitted that Kalu used to take instructions from Sohail, who was planning to carry out a bomb blast. And there was a blast code as well that was to be called out by Kalu. And this again was proved with the call detail records and with the NIA investigation later on. This fact was not known to the police at first, but later it was found out. And it does have evidentiary value as per section 27 of the Evidence Act, as stated. It is also to be noted
Why do
here.
you say so? It has evidentiary value under section 27.
So through the call records, I mean, sorry, again, the prosecution witnesses' statements, they helped in tracing out where these whereabouts of these people. And then when those people were traced, the call details came in into hand as well, Your Lordship.
But call details, will it come under section 27 or not?
The call details
Because
themselves will not.
because the call details are nothing tangible. It's only a record which you get from maybe the telecom operator. So how do you bring call records under section 27?
The council needs ignorance with that.
All right. That's why I asked you initially, how do you prove call records?
Okay, Your Lordship. Can I move
Yes, you
along?
can continue.
Okay, thank you. So, moreover, coming to the call records, it showed that Kalu was in West Bengal, very close to the borders of Bangladesh. He was in constant touch with all the other accused who was planning to attack the Indian convoy. In the absence of any direct evidence, a person can be convicted on the basis of circumstantial evidence, and this must be
What
treated as though.
what is the law for proving for convicting a person under circumstantial evidence? Which section of IP Evidence Acts deal with that?
So, Your Lordship, even that will be mentioned by my co-counsel in the next
Okay.
section. So, the council further states that as per section 436,
Continue.
it's a clause 1 of the CRPC, it lays down the conditions for bail, and this is a non-bailable offense, and the council submits that bail should not be granted for the accused in this case.
So your case is that the accused should not be granted bail, or he should be convicted.
He should be convicted and should not be granted bail.
See, if it was bail, then the defense should have argued first. They should have proved their case for bail. But since you are arguing first, it shows that after all the evidence has been taken on record, it's on at the argument stage, and you are pressing for the conviction. At this stage, bail in any case will not be granted. So, anything else you want to argue?
Nothing, Your Lordship. The issues 1 and 2 have been dealt with. My co-counsel will be dealing with the third issue.
The council seeks permission to move on to the third contention. The third contention is whether the stated accused had plans to disrupt the government of India. It is submitted before the Honorable Patiala House Court, New Delhi, that the stated accused did have plans to disrupt the government of India, which was in a way waging a war against the government financially and also physically. As per the facts of the case, accused 1 and 2 were caught red-handedly by the officers of the PS Special Cell of Delhi Police, Lodi Road, New Delhi, with fake Indian currency notes at Old Delhi Railway Station. The currency almost amounted to 10 lakh rupees, and the further investigation was handed over to the NIA. In the NIA investigation, upon interrogation of the accused, the accused arrested in the railway station revealed that there were approximately 5 lakh fake currency notes to be delivered to the Peter A4 in Pulwama, and that amount is further utilized for bomb blast on Indian Army convoy on 15th August 2015. As per Section 26, the confession made by the accused can't be used against him. However, the admissions led to evidences which provided the link of other people and proofs as such, which provides sanctity under Section 27. So to begin with, the accused were caught red-handedly with FICs, and they were already recovered and established the act as reals. And the second evidence is the call detail records. In this regard, the call detail records of A1 shows his presence in Malda on 24th and 25th of July and 25th and 26th of September, and also on 5th February he was found. His call locations were found in other places of West Bengal, like the Bardhaman and the Birdham districts. So, according to Section 15 of the Evidence Act, the technical evidence of A1, his location, provides a substantive evidence on his part in the attempt to disrupt the government of India. The accused A1 admitted his involvement in the case and disclosed the involvement of other accused, Kalu and Peter, and also Sohail in the process. And he was further, though the accused claim that they lack knowledge of FICNs and the terrorist activity, it is a basic thing that the only possessions found with A1 and A2 were their phones, the SIM cards, the identification cards, and the FICNs. It is logically improper to say that they had no knowledge when the only thing that the bags contained were the FICNs. And as per CDR analysis of mobile number of Monu A2, it shows that his mobile was switched off from 3rd February to 7th February, which indicates that he
Madam,
cleverly
now
switched off.
I'll again come to the question I asked the first speaker. How do you prove call records?
Okay. Sir, according to Section 65 of, I'm sorry. According to Section 65 of the Indian Evidence Act, the records had been certified by the respective authorities, and they hold the certification to be provided to the Lordship.
Was that done?
Yes, Your Lordship. After the certification, they were submitted to the court.
All right.
Okay.
Which section says of the Evidence Act says that the certificate is required?
65B, sir. 65B.
All right. Secondly, kindly explain for a conviction under UAPA, sanction is required.
Sorry, sir. Sorry, Your Lordship. Can you repeat?
I'm saying, is sanction required for prosecution under UAPA, sections of which have been added against the accused?
One moment, Your Lordship.
What are the sections invoked against the accused?
Oh, okay. The sections invoked against the accused were sections 120B, the criminal conspiracy, and other sections which mentioned destroying of the evidences and
Section
UAP
201?
201. I'm sorry, Your Lordship.
Yes, continue.
Okay. And then further, the call record details of A2 were also found to be found that on 3rd February to 7th February, the mobile phone of A2 was switched off, which also provides the corroborative evidences that he was in the part of the plan, like he was a part of the plan. And also, the information confessed by A1 and A2 had given leads to the conspiracy by A3, A4, and A5, which makes the confessions made by the accused in the police custody admissible and valid. And as per
To the extent of recoveries, right?
yes, sir. And A3, as per A3, in the defense witness, A3 Kalu, he mentioned in his statement that he received funds from across the country of Pakistan and Bangladesh for the upliftment and the sensitization programs. These programs, when conducted in the past in the village of Malda, such team was declared unlawful assembly. So this provides an evidence that the financial assistance had been provided to unlawful assemblies.
What is an unlawful assembly? Which
An
section
unlawful-
of IPC deals with it?
Unlawful assembly is, sorry.
Your researcher can come in and says if
Sorry, Your Lordship, 141 section,
off.
Indian Penal Code.
Okay.
And
Has 141 been added to the charge sheet against the accused?
I guess so, Your Lordship. I'm sorry about that. No, it was
You
not.
can look at the problem.
No, it was not added in the charge sheet.
Then how can you say there is no unlawful assembly? Section is not
The
added.
unlawful assembly is regarding a different case. However, it provides as a corroborative evidence in this case. An FIR was filed in the as such for the unlawful assembly.
But an FIR has been filed. Is this trial for unlawful assembly, yes or not?
No, it was not a trial for unlawful assembly. However, the police declared it an unlawful assembly and filed an FIR in that regards, and hence they are using it as an evidence to prove against the defendants. To continue, there was corroborative evidence. An independent eyewitness, Shah Rukh Khan, who claimed that he had seen Sohail, Kalu, and an unknown person, in black kurta on 20th June 2015 at about 8:23 a.m. to be infiltrating the India-Bangladesh borders. So we have provided his statements as well. The Samir also disclosed various names in organized supply and purchase of the FICNs. And during the NIA investigation, Kalu destroyed the evidence to his offense against the state. It was only the accused who had the opportunity and the reason to destroy the evidence with the intention to save himself from being identified as the perpetrator of the crime, and concluded that there remained no doubt that it is him who destroyed the evidence. And this had the sanctity of the case of Ramesh Gudu versus State, which also had the similar case where NIA found the witness accused with fake Indian currency notes. Also, the accused denied any and all confessions made during the investigation with relation to the disruption of the government of India. In Sarda versus State of Maharashtra case, it was also held that the false explanation or a false plea taken by the accused can be used as an additional link in the chain of circumstantial evidences, subject to satisfaction of 3 other essential conditions. And our present case proves that. And as for the question the Lordship asked before, whether the technical evidences of call record details is admissible as per the Evidence Act, all the accused have illegally infiltrated in the foreign territory, which amounts to an offense against the state security of the state, and dealt with foreign codes in much greater detail than Indian Penal Code. The accused were known to each other and they had stayed in contact for quite some time. This fact is also corroborated with scientific or technical evidences, that is called detailed records of the mobile numbers of the accused, showing the communication between the mobile numbers. Also, prior to that, a few calls were made in relation to the conspiracy and the terrorism. These call records between the accused sufficiently corroborate the dispositions of NIA that the accused were known to each other, as per Ramesh Gudu was the case as Supra mentioned. The records have been necessary certification as required under Section 65B of the Indian Evidence Act, and also this evidence can also be admitted as per other acts, as in Official Secrets Act 1923, Unlawful Activities Act 1967, and also by all of these acts mention that spying or entry into prohibited areas of other countries or providing secret information collection.
Madam, tell me one thing. You are representing NIA.
Yes, sir.
What is the procedure to hand over a case to NIA, and what kind of approval or sanction is required for NIA to file a charge sheet?
As already mentioned, there was excuse me. Terrorist-related cases are when there are cases related to terrorism, then the cases can be handed over to NIA. Also,
has terrorism been defined in under any act in India?
UAP and the TADA Act.
TADA has been repealed. So
Yeah. However, Unlawful Activities Act do mention about terrorism and other stuff related, and also the current case had been directed to NIA by the Ministry of Home Affairs, the Government of India, via its Order 26/2015, dated 30/4/2015. So it was further revealed that the FICNs were a much bigger conspiracy and terrorism than it first appeared to be. So to continue with, um, all the activities done by the accused, they had a thing in common, and that is the normal tranquility of the civilized society in each of the cases were disturbed either by the actual force or at least by show or threat of it. So the current case is a matter of national security and giving bail to the accused and putting such national security under greater jeopardy. We are also mentioning the case of bail because the case is not yet completely investigated. So
Madam,
in such regards,
if the case has not been completely investigated, investigation is not complete, that means your charge sheet is incomplete. If your charge sheet is incomplete, then how can we at the argument stage, if you that means you may
the
file
basic
some, yeah.
yes, your lordship, the basic investigation has been done, and the further investigation for A5, A4, and A3 are to
Just
be done.
answer one thing. If the investigation is not complete, can the matter reach at the stage of argument?
No, sir. The investigation,
Then what are
as
we
in
doing
at
at the
basic
moment?
levels,
What are we doing at the moment? Is it not the
we
final argument? That
yes.
means your investigation is complete.
Okay, sir. Okay, sir. The NIA as an investigation force is required to take steps to unravel the larger conspiracy, including the clandestine terror activities of the accused, their association with other organizations like the Lashkar-e and the other terrorist organizations mentioned. So their possible locations in India, the abroad, and the sources of funding, etc., are to be recovered. So besides, the requisitions were sent to concerned service providers to the CDRs of all mobile phones recovered and the other members by the accused in view to analyze the same for establishing the linkages between the accused or suspects and the field verification needs to be done. So it is further submitted that the investigation is proceeding in the right direction. Since the accused are hardcore ideologists, detailed further investigation is inevitable to collect more evidences and for unraveling the larger conspiracy behind the crime. So there may be imminent threat to the security of the nation if the accused are not interrogated in detail, more evidence is not collected, and detailed investigation is not done to identify and secure other members of the group. So, in order to be assured of the truth of confession, this court, in a series of decisions, has evolved the rule of prudence that the court should look to corroboration from other evidences. However, there need not be corroboration in respect of each and every material particular. Broadly, there should be corroboration so that the
Continue.
confessions taken. Sorry. I'm sorry. Broadly, there should be corroboration so that the confession taken as a whole fits into the facts provided by the evidence. And the accused entered into a criminal conspiracy to disrupt the peace and tranquility, to wage war against the state in order to overthrow the government by financial aid to militant groups. Prima facie, the allegations contained in the charge sheets are supported by the contents of the statements recorded, and the gravity of the offences allegedly committed by the appellants enlarged that the appellants need not require a bail if they ask for one. And the material on record prima facie shows their complicity, and there are reasonable grounds for believing the accusations against them are true. And we request Honorable Court to issue a warrant of arrest against A5, who is absconding since this case is in relation to the security of the nation. And having regard to the nature of the allegations made in the charge sheet into consideration, the fact that in offense of this nature, namely trafficking of forged counterfeiting money, currency notes, pose a challenge to the economy of the country, which virtually amounts to waging a war, a financial war against the country, and the accused are requested to be charged accordingly. Also, we also would like to mention the points where carrying the bag without only with the FICNs without any other things, provided they do have the knowledge and having contacts with each other, and A1 and A2 mentioning that, stating in their defense witnesses that it was Kalu A3 who had actually asked them to carry the bags, and all prove that there was knowledge and there was a conspiracy, and carrying of FICNs led to a financial war, and also giving financial assistance to other militant groups, and hence we ask request the court to charge them accordingly. If the court is satisfied with the charges and all, the council seeks permission to mount the prayer.
Okay.
Wherefore, in light of the facts of the case, issues raised, arguments advanced, and authorities cited, the Honorable Court may declare that the stated accused had plans to disrupt the government and who are involved in a criminal conspiracy, had the knowledge and the possession of the counterfeit money to be charged as per the charges mentioned in the charge sheets, and to pass any order in favor of the prosecution counsel that may deem fit in interest of the justice, equity, and good conscience. All of which are respectfully submitted. Thank you.
Okay. We can have team 532 now.
May it please Your Honor, the council seeks the permission to begin.
Speaker 1, you can try again. Just speak, say something. No.
May it please the court, the council seeks the permission to begin with the proceed.
Yes, you can.
Much obliged, Your Lordship. Much obliged, Your Lordship. I'm counsel number 1 representing the defendants in the instant case, that is State versus Soumya and others. Lordship, in this case, 5 issues have been raised, and if you may permit, the counsel number 1 will proceed with 2 issues, that is issue number 1 and 2, and the rest of the issues will be dealt by my co-counsel.
Yes, continue.
Much obliged.
Proceed.
If please the court, the counsel seeks the permission to briefly narrate the facts.
Please proceed.
Much obliged, Your Lordship. Based on the information given by Guddu Singh on 24th of February 2015, a team of Special Cell of Delhi Police conducted a raid of General Coach number 2 of Farakka Express train at Old Delhi railway station on 25th February 2015, and the events which transpired after the raid was as follows. After identifying the accused Samir, accused number 1, and Monu, accused number 2, they were detained and primary search was carried on. In the bag of accused number 1, fake Indian currency notes having the value of 5, and also the same amount of fake Indian currency notes, that is 5 lakh, were found from the bag. Moreover, the person sort of the accused, some mobile phones, SIM cards, some IDs, a small amount of cash, and real tickets were recovered. After the seizure of the said items, an FIR was at the Special Cell Delhi, New Delhi. During the investigation, several names of the associates were disclosed by the accused number 1 and 2. That is Kalu at Mama, accused 3, and Peter is the accused number 4. The Special Cell Delhi Police forwarded the C5CN currency notes to the CFSL CBI, New Delhi, for their opinion. And all the notes that were received were, as per the opinion, all the notes that we received were high quality fake Indian currency notes. Subsequently, the investigation of the case was taken over by NIA, and the team of investigators were sent to search the house and access of accused number 4.
Madam, one thing, are you admitting all these facts?
Your Lordship.
Are you admitting all these facts? Which you have just
No, Your Lordship. Your Lordship.
Continue.
Much obliged, Your Lordship. The accused number 4 was found absconding, and later on it was found that he was already dead on 27th June 2015. The NIA team was also sent to Malda to examine accused number 3 and searched his house, where they seized many items. During the investigation, it was in frequent communication with mobile number of accused 4, 1, 2, and Soumya, who is accused number 5. And when he was arrested and questions about the involvement and accused number 5, it was revealed that he had crossed the border at night and went to Bangladesh. And when the house of accused number 5 was searched, nothing could be recovered. If your lordships are clear with the facts, counsel seeks the permission to proceed with the arguments.
Continue, proceed, please.
First issues which has been raised is whether the mere possession of fake currency constitutes criminal conspiracy under Section 120B of the Indian Penal Code and Section 18 of Unlawful Activities Prevention Act. It is honorable code that the accused are guilty of criminal
Can you please turn
conspiracy.
off your video? Your voice is not very clear. Just switch off your video so that your audio will become very proper.
Sure, your lordship.
Continue now.
Whether the mere possession of fake currency constitutes criminal conspiracy, Section 120B of Indian Penal Code 1860 and Section 18 of Unlawful Activities Prevention Act 1967. It is humbly submitted before this honorable court that the accused are not guilty of criminal conspiracy under Section 120B of IPC and Section 18 of Unlawful Activities Prevention Act. Firstly, Section 120B of IPC provides with the punishment for criminal conspiracy, and Section 128 defines criminal conspiracy. In order to constitute an offence under Section 120B, an agreement between 2 or more persons is necessary, and the agreement must be for doing or causing to be done an illegal act. An agreement implies the meeting of two minds with reference to a particular matter. Hence, it is necessary to point out the common object of all the persons involved. However, in the present case, there is no common object or an agreement for an illegal act. As per the statement of...
Madam, just let's look at the facts. You were caught red-handed with fake currency, correct?
Yes, your lordship.
So, the accused were caught with fake currency. That means that some offense under the act has been made. Using fake currency itself is an offense, and being in possession of fake currency shows that certain illegal things were to be done. So, and more than one person was involved, therefore it was a conspiracy to at least use fake currency. So how can you not say that there was no conspiracy?
Your lordship, the issue regarding the fake currency will be dealt by my co-counsel, and all the doubts will be cleared. Your lordship.
Secondly, as it was argued, the call record shows that you are in touch with each other. If you are speaking with each other regularly, fake currency, again your co-counsel will address that aspect, but you are in touch with each other, something illegal has been obtained from your possession. Section 25 at least protects that you had a knowledge of that particular object which has been recovered. You were in touch with each other. Therefore, the basic ingredients for criminal conspiracies have been met with. You people who can be at least convicted under 120B. How will you come out of it?
Your lordship, your question will be answered in a while.
All right, proceed.
Okay.
I'm
Thank you.
waiting for the answer. Continue.
Your lordship. However, in the present case, there is no common object or an agreement to do an illegal act. As per the statement
Again, what is common object?
A common object is when the 2 or more persons agree to do an illegal act.
Correct.
It is further submitted that the
Continue.
that the accused persons did not do or cause to be done any illegal act. In the present case, there is no criminal intention of the accused persons. They were merely the members of an organization. They were active members and helped in raising funds for organizing sensitization programs for the upliftment of the backward.
Again, your act of possession of illegal currency shows that something illegal was to be done. being in possession of illegal currency shows there was mens rea to do something wrong with that currency. How will you come out of it?
Your Lordship, the accused persons were the members of a organization where they worked for the upliftment of the society, and for that organization they were collecting funds, and they were
But
not
certainly
aware.
collecting funds and in being in possession of illegal currency are two different things. You
Yes,
may
your
be
Lord.
you cannot use illegal currency for upliftment of people.
Yes, your Lordship. But the accused here, they were not aware of the currency which they had. They did not know the currencies were fake, as their intentions were very towards the
Secondly,
upliftment of society.
secondly, you are in possession of such a large amount of cash, 5 lakh, which is not justified. You cannot be travel with so much large amount of cash. Certainly, it should be having in bank account. Electronic mode should have been used to
Um,
transfer the amount. Traveling with such huge amount of cash, and that too with something illegal, shows that there was common object. How will you come out of it? First first problem is having large amount of cash. Second is that was illegal currency. That prima facie shows that prima facie shows that something illegal or something contrary to law, illegal thing was conspiracy was being hatched. Yes. Now you can continue, ma'am.
Your Lordship, as per the statement of defense witness number 1, he was a driver by profession who worked for sensitizing the people and conducted skill development training in order to empower the villagers. And for that purpose, he was entrusted with the work of raising funds. Hence, the accused are wrongfully alleged, as their objective was to only to create awareness and uplift the poor. And the funds, they were not aware that the funds which they were using were fake Indian currency notes. And as already stated by the defense witness, he was a driver by profession, so he did not. He was not that aware that whether the whether the notes he was carrying were fake or not fake. So they cannot be held guilty of criminal conspiracy under Section 120B of Indian Penal Code. Secondly, the accused persons have also been charged under Section 18 of the Unlawful Activities Prevention Act 1967, which punishes the ones who conspires, attempts, advocates, abets, or knowingly facilitates the commission of a terrorist act. It is contended that the accused persons have not committed any of the said activities provided under this section. As stated above, they were merely volunteering in an organization, and there is no single evidence which proves their guilt, and there is no any evidence which shows their involvement in conspiring and abetting a terrorist act. Thus, there is no single
Ma'am,
link.
what are can you just touch upon Section 18 of UAPA? What are the ingredients of Section 18?
Section 18 punishes the ones who conspire, attempts, commits, or advocates, abets, advises, or knowingly facilitates the commission of a terrorist act.
Okay. So in this case, what terrorist act has been committed according to the prosecution?
Pardon, Your Lordship?
What kind of terrorist act has been alleged to be committed by you people? Why is Section 18 invoked against you?
Your Lordship, section number 18 has been invoked because they were found with the high fake currency notes, and also it was disclosed during the investigation that the co-accused had disclosed that the accused number 5 was planning to carry out something against the state.
All right. Proceed.
So therefore, there is not a single link which proves their guilt. Thus, they are not guilty under Section 18 of the UAPA Act. Therefore, the charges against the accused persons are false, and they cannot be held guilty of the offences under Section 120B of the IPC and 18 of the Unlawful Activities Prevention Act. If your lordships are satisfied with the arguments, the council seeks the permission to move to the next argument, that is, next issue. The next issue which has been raised is whether failure to recover evidence by the police can lead to the accused being guilty of causing disappearance of evidence under Section 201 of Indian Penal Code. It is humbly submitted before this Honorable Court that the accused persons are not guilty of offence under Section 201 of IPC, which deals with causing disappearance of evidence of offence or giving false information to the screen offender. In the instant case, the accused persons did not screen any offender, as they were simply a part of an organization working actively for the society, and they had no knowledge of the alleged offence for which the police were investigating them. There is neither any commission of offence nor disappearance of any evidence. Moreover, the accused persons had cooperated well with the police, and they had confiscated everything that was recovered from the accused persons. So it shows that there is no attempt from their side to disappear the evidence. It is further submitted that conviction under Section 201 is given only after the prosecution is able to prove the main offence. It was held in Hanuman and others versus State of Rajasthan that the prosecution should be able to prove the main offence. Unless the main offence is proven against the accused, conviction cannot be done under Section 201 of IPC. Furthermore, the accused persons in this case have not withheld any information from the police during the investigation. They only exercised their right conferred by the Constitution under Article 20 Clause 3, that is right against self-incrimination, because they did not do any wrong. And as per the statement of defense witness 1 and 2, they felt unconscious as they saw many policemen, and that's the reason they were exercising the right guaranteed under Article 23 of the Indian Constitution. Further, the Honorable Court in Nandini Satpathy versus P.L. Dani held that the rights guarantee under Article 20 Clause 3 applies not only in the courtroom but also in the police, also during the police investigation, to protect the accused from the self-incriminatory statements. Therefore, the accused persons were scared when they saw policemen. They did not do any wrong, and in order to protect themselves from false allegation, they used their right against.
You were scared because you were in possession of illegal currency, that too in a very high volume.
No, Your Lordship. The accused said
anybody having 5 lakh rupees cash will be scared to see a security official.
No, Your Lordship, the accused have stated that they didn't do any wrong, and because of the large number of policemen, they feel unconscious.
You are accused, you will definitely say that you have not done anything wrong, but your action says having illegal currency with you shows that something wrong was being intended to be done with that currency.
Your Lordship, the accused were also not aware of fake Indian currency notes, and there is not a single evidence to prove their guilt. There's not even a single link which shows that they are guilty of the offence. So,
all right. Conclude your arguments.
Therefore, the accused only used their right to remain silent, and they did not do any wrong. They were merely a part of an organization who raised funds for upliftment of the society. Therefore, the accused persons...
Can you elaborate what do you mean by right to remain silent?
So, right to remain silent is that the accused, whoever a suspect, have the right to remain silent when they are being investigated. They have the right not to say anything against, which would probably link them to an offense or any charges.
But that would also amount to non-cooperation with investigation.
Yes, Your Lordship, it would amount, but they have the fundamental right to remain silent. And again, in this case, the accused they did not They were very
See, there's a
cooperative.
difference between not saying anything which would incriminate you and not saying anything. It's American jurisprudence that you have a right to remain silent. Indian jurisprudence says you have to cooperate with the police investigation agencies.
Yes, Your Lordship, but the accused persons had cooperated well. They had
Just
the
tell
police.
me one thing, Madam Speaker.
Yes, Your Lordship.
For NIA to your case is being investigated by NIA, which prima facie shows that it's a
Indeed,
very heinous and serious offense.
indeed,
So,
Your
what
Lordship.
is the procedure for handing over case to NIA, and what kind of sanction is required, and whether that sanction has been taken or not, or
Um,
whether your co-counsel will deal with it? Then you can say that my co-counsel will deal with it.
Your Lordship, I'm not aware, pardon, I'm not aware of the process of handling the cases to NIA, but in this matter, the case was handed over to the NIA because of the.
But if the procedure has not been followed of proper handing over to NIA, that's a loophole in investigation, and the entire investigation goes. So that should be your first primary objection, that something proper has not been done, the investigation is not proper procedure has not been followed. I should be acquitted.
Your Lordship, we are not aware of the
Okay.
procedure, so we look into
Okay.
it, Your Lordship.
Yes. Yes.
Therefore,
In
Lordship,
any case, the prosecution says that their investigation is not complete, so you have further time, I guess.
therefore,
Continue.
Your Lordship, if the Lordships are satisfied with the arguments, now my co-counsel would be dealing with the rest of the
Yes.
issues.
Just 30 seconds and the co-counsel can start.
Sure, Your Lordship.
Yes, Mr. Co-counsel.
Co-counsel seeks permission of His Honorable Court to proceed.
Continue.
Much obliged. If this court is well acquainted with the facts of the present case, may this counsel present the argument.
Let's continue.
Much obliged. Um, the first issue that I'm going to deal with is whether the accused are guilty of possessing and using counterfeit currency. It is humbly requested and contended before this honorable court that the accused are not guilty of possessing and using counterfeit currency under section 489B and 489C of IPC. Uh, Your Lordship, for the application of section 489B and 489C, it is necessary to show that the accused had reason to believe and knew that the notes kept in his possession was forged, and there has to be intention to use it as genuine currency. It is contended that the accused did not have knowledge that the bags had fake Indian currency notes, and they have already said that in their statement, because they have said that they were asked to carry the bags by accused number three, uh, since they were part of an organization which you look to carry out upliftment programs uh, in India, and and it has been held in the case of Sundarlal versus State and City that mere possession of counterfeit currency is not enough to establish guilt. The organization that the accused were part of received funding from various people across the country, and the funds were collected by accused number five, and accused number three also had no intention, and he had no knowledge that the funds that were collected by accused number five were fake. He was merely given the currency so that they could carry out their programs of the organization. And though accused number 3 had intention to use this currency, he had no idea that it was fake. So the application of section 489B and 489C can be done in this case because they, they had no knowledge that the fake currency that they had received from accused number 5 were fake. And the acts done by accused number 1 and accused number 2 also cannot be considered as an offense because it
Mr.
was done.
Counsel, can you, under Evidence Act, there are certain kind of presumptions, right?
Yes,
Indian
sir.
Evidence Act, certain presumptions can be made, right? You were in possession of certain currency notes which are fake. Prima facie presumption would be made that if you are in possession of notes and they were fake, so it can be made, we can make a presumption that you are aware that these currencies are fake. See, Mr. Counsel, there are two things. If certain currency notes are fake, admittedly, certain fake currencies in circulation, by mistake they may come into your possession. But it's highly unlikely that entire bunch, the entire currency, all the notes are fake. So the source from where you got the currency would be doing something illegal. It's highly unlikely that each and every note was illegal. So it shows that you had knowledge, or at least the source from where you got the currency was somewhere trading or dealing with illegal notes.
Mm, Much obliged, Your Honor. That is what I was going to argue, that the accused that were caught with the fake currency, the accused number 1 and 2, they had no knowledge that the currency that they were given were fake. And what they did was, the action that they did was in good faith for the organization that they're working for, and they had no reason to believe that those currency were fake, as if the currencies the fake the currencies and the funds that were collected by accused number 5 and given to accused number 3 so that he could give to the workers of the organization
See,
that were A1 and A2.
see what should have been done. Correct. Accused number 5 collected or sourced the money. He gave it to you. The only thing you were supposed to do it was go to a bank and deposit it, because nobody's supposed to carry 5 lakh rupees with him in cash anywhere. The mere reason that you didn't go to bank and you proceeded to spend it somewhere else or use it somewhere shows that somewhere you had the knowledge that this currency cannot be deposited in the bank, and should be sourced or spent somewhere else. So now you can proceed, Mr. Counsel. Now.
Um, yes, Your Lordship, the accused were only asked to give those fake currency to accused number 4, so they were merely doing the job of the organization that they were part of. So they are.
Correct. You're not audible.
Yes, sorry, sir. Sorry. They were they were not aware that those currency were fake, so they were just doing the part of the organization. The main person who was collecting the funds
All the
was.
more reason, Mr. Counsel, your organization gave you fake currency notes, shows that the entire organization somewhere uses fake currencies. Using fake currency, and that too, all the other evidence which is against you, prima facie establishes something illegal, something prohibitive was being done, unlawful activity was being done.
Master Base Honor. Uh,
Continue, Mr. Counsel.
um, if uh, if the honorable court is satisfied with this argument, may the counsel please proceed with the next issue.
Yes, yes.
And the next issue is whether the accused are guilty of attempting or attempting to or wage war against the government of India. and it is humbly submitted before this court that the accused persons are not guilty or to attempt or to abet war, to wage war against government of India. Um, to constitute this offence, the accused should have attempted to wage war against government of India. But there are no links to prove that they were.
Mr. Counsel, kindly, which section of IPC deals with waging war against the country, and what are
Uh,
the ingredients of it, and how you are out of it?
Section 120, Section 121 and 123 of IPC deals with um, attempting to wage war against the country, and the essential is that there has to be a motive to prove that they were waging war against the government of India, and that there there has to be a concealed design as to how they were going to go about with the action, and there are no links to prove that they were attempting to wage war. They were only caught with fake currency, and they were part of an organization that was mm, that that you work for upliftment programs. So there was no link to prove that they were attempting to wage war. And in and to constitute an offence under Section 121, the alleged act should be directed to disrupt the sovereignty of the state, and the mere commission of the crime, which the prosecution says that possession of fake currency is a crime, and that cannot be enough to prove that they were waging war against government of India. There was no motive, and as it has been stated in the case of NCT Delhi versus Navjot Sandhu, mm, to constitute offense under 121, there has to be a warlike operation, which is not seen in this case. And the accused also did not conceal any design or knowledge that they had to facilitate a war against the state. Statement of prosecution witness 2, that is Iqbal Khan, has said that accused number 1 and 2, though they were working together with accused number 3, uh, they were working for another organization that worked together for the upliftment of marginalized people, and this can establish that they were waging a war against government of India. And
Mr. Counsel, somewhere in the fact it has been given that across the border from Bangladesh and Pakistan, you are in contact with people, you are in possession of fake currency. If fake currency is coming from outside India through your organization given to you, shows prima facie that money was being used to some do any activity. See, any activity. See, Mr. Counsel, any bomb blast, a very serious activity, heinous crime, one in which lots of lives are lost, may not be the act of war against the country. Even a very small act, which which may appear to be very small to the people, will also act as a war against the country if ingredients of Section 121, as told by you, are matched or are present. In this case, prosecution, as the case which has been given, shows that you are in touch with neighboring countries from where money was sourced. You are in touch with other people across the border through your call records. You are, which shows that you had some link with people across the border. You were caught with fake currency. Presumption can be made that that money was being used to do some illegal activity. Illegal money, illegal currency, prima facie will be used to do some illegal act. How will you come out of it? And how can you explain your conduct, conduct and contact with people across the border?
Your Honor, Your Lordship, the contact and the evidence does prove that the court records does prove that the accused accused number 5, the one who has been absconding, he is the one who is in contact with people from across the border. The accused who have been charged in this case, that is accused number 1, 2, and 3, they have not, the court records don't show that they were in contact with people from
So
across the border.
see the chain. Across the border, were in contact with A5. He is the kingpin. You people are minions. They conduits. They accused number 5 gave you money to carry out some illegal activity. The chain seems to be complete. Across the border to A5, he giving instructions to A1, A2, A3. So a proper organization setup is there. A proper channel is there. How will you come out of it? Each and every person is not supposed to do all things. Every individual has been given a task, have been assigned a task to do some illegal activity. The entire organization, the network shows that something big, a conspiracy was being hatched. How will you come out of it?
Your
Anyways,
Lordship,
Mr. Counsel, you can continue with your arguments after this.
Your Lordship, the accused that have been charged in this case, as accused number 1 and 2, though they were part of this organization, they had no knowledge that A5
Continue.
A5 was in touch with people from across the border, and the main conspirator, that is A5. A5, they had no links with A5. They were merely asked to carry the bag because they were part of the organization. So they can't be charged with waging. They can't be charged with the offense of waging war against the government.
Mr. Counsel, that's why Section 120B of conspiracy is there. Each and every person need not do all the things. If an organization A1 does something, A2 does other thing, A3 does other thing, together it constitutes a offense, then all would be treated at par, that as if each and individual act has been done by them all. Isn't it what Section 120B says?
Yes, Your Honor. That Your Lordship, their intention, however, though they were part
Section
of the
120
organization,
says, continue.
though they were part of the organization,
Section 34 of IPC, what does it say?
Section 34. Section 34 says that. Just a moment, Your Honor.
Have you been charged under 34? Yes or no?
No, no, no,
Read
Your Lordship.
34.
No, Your Lordship. They had common intention, so they had no common intention, Your Lordship.
Mr. Counsel, in any case, if you haven't been charged under 34, it cannot be invoked against you. But since across the border, A5 was in touch with them, he gave illegal currency to you to carry out some illegal design. Country was in, lucky that police preempted you and caught you, and the nefarious design was not carried out. But certain things was their planning was there.
Uh,
Anyways, continue. We want to conclude your arguments if you have anything else to say.
mm, yes, Your Lordship. The other issue that they have been charged with is being a member of a terrorist organization, and
Ha-
uh,
has your organization been declared a terrorist organization? Yes or no?
no, Your Lordship. Our
Okay.
organization has not been declared a terrorist organization.
Okay.
We have, the accused have just been linked with the terrorist organization, and then and there are no links to prove that they were part of that organization, that is the Lashkar Toiba, and it is humbly submitted before this court that the accused persons can be uh, found guilty of being a member of a terrorist organization just merely because they were part of some other organization that worked together. And since that organization has not been declared as a terrorist organization, they can just be uh, guilty of being a member of an organization, a terrorist organization. Sorry.
All right. So, what do you want in end? What should be done?
Uh, if the court is satisfied with the arguments, the council would like to get along with the prayer. Um, in light of the issues raised, arguments advanced, and authorities cited, may this honorable court be pleased to acquit Samir, Monu, and Kalu for the offence of committing criminal conspiracy under Section 120B and abetting to wage war against a government under Section 121 and 123 of IPC, and possession of using counterfeit currency under Section 489 and 489C of the IPC, and being a member of terrorist organization and raising funds for terrorist act under Section 17 and 20 of the UAPA.
Okay. Any rebuttals by the prosecution?
Yes, Your Lordship. If you
Yes.
Thank you, Your Lordship. The Speaker 1 mentioned that the essentials of the criminal conspiracy weren't established. However, the contacts between the accused proved that they had a common object, doing an illegal activity with the agreement to do it through illegal means. And also, it was stated by the Learned Counsel of the Opposition in Issue 3 that the statements by the accused A1 and A3 cannot be taken as evidences as they do not corroborate. But it is humbly submitted that, as per the conditions laid down in the Padmaraja Shetty and others versus Union of India, when the statement is made by an accomplice in a separate testimony, it can be treated as a corroborative evidence, and therefore the statements by A1 and A3 does have evidentiary value as it corroborates and helps with the further findings in the case. And even if the accused say that they don't have the knowledge that they were fake, the currency notes were fake, they were still supplying the money for an unlawful assembly against the government with the knowledge. This proved that they had the intention to disrupt the government of India. Also, the last point of the rebuttal, as per Section 8.
You never argued this aspect 121, 120 of IPC.
Sir?
Section 121 IPC, did you argue on that?
Unlawful assembly, no, sir, but we did mention it along with the FIR.
Okay.
Yes, sir. And also the last point, as per Section 8, motive, preparation, or subsequent conduct, A3 destroying the evidences and A5 absconding provide the proofs which the defense says isn't existing. Thank you, Your Lordship.
All right. Anything else? Speaker 1?
Your
Defense?
Lordship, as stated by the counsel of the petitioner, they said that the accused they had the intention of doing something against the government of India, but the funds which they were collecting or whatever they were doing, but their intention was not against the government of India. They were just collecting the funds for sensitizing the people, and also the confession of co-accused cannot be a substantive evidence as held in Hari Chandra Kumari versus State of Bihar, and the confession of a co-accused cannot be the base of conviction. Lordship, with this I would conclude my rebuttal round. Arguments for rebuttal round.
Speaker 2 of 553. Anybody? So now
Your
I'm
Lordship.
just opening the floor for everybody. Both the speakers of both the team as well as researcher. 1 minute to both. Anything you want to add before we conclude? Researchers can also come in now. First the prosecution, then the defense.
Just a moment, Your Lordship. As mentioned by the Speaker 1, they said that the confessions made by the co-accused can't be used as a evidence. However, we are using it as a corroborative evidence and not as a substantive evidence, not taking it as a base of the case. And also that there was an intention, because intention at least to be a part of an unlawful assembly, which eventually leads to disruption to the government. So these are the points against the defense.
All right.
Thank you, sir.
Anything researcher of 553, speaker 1 of 553, anything you want to add? Then I'll give the chance to 532.
As the speaker of the prosecution said that the confession has just been used as the corroboration, but here the major reliance has been only put on the statements or the confession. There is not a single evidence or link. On the basis of the statements, the case is brought before the honorable court. So
All right.
that's what I want to point out.
So can we conclude now?
Sir, I have a rebuttal, sir.
Yes.
So we
30
have
seconds.
almost We have the evidences of FICMs. We have the defense witness statements made by the accused themselves, and the CDRs and the eyewitnesses against the defendants as the evidences, not just the statements made by them during the investigation. So, yes, sir.
All right. Shall we conclude now, everybody?
Yes, sir.
All right. All of you were really good. Really good research, really good articulation. All the best to all of you. Really impressive.
I would like to thanks once again the honorable judges and dear participant, and I think Mr. Honorable Judge, our Ravi Kaushalji is also here. I just request to him just conclude with one single remarks, if can make. I think unfortunately I'm just trying to connect with him. Thanks, dear participants. Thanks for the same and best of luck for your results. और अभी जुड़ नहीं पा रहे हैं रवि कौशल जी, और आपका धन्यवाद करते हैं और रिक्वेस्ट करते हैं कि पहले पार्टिसिपेंट लिंक को छोड़ें, उसके बाद जजेस। थैंक यू वेरी मच।
I request, as said by the Adhivakta Parishad, I request all the participants to leave.
Thank you, sir. It was
Thank you, sir.
Thank you, sir.
Thank you, sir.
All of you were really good,
Thank you.
really impressive. Thank you so much.
So, it was really impressive. Thanks a lot, all of you.
Thank you, sir.
चले गए ना सर?
हाँ सर, सब चले गए।
मैं मार्किंग करके भेज रहा हूँ।
Please, sir, please.
रवि सर, थैंक्स अ लॉट सर।
रवि सर, आप सुन सकते हैं? मैं ऑडिबल सर?
हाँ जी,
ऑन कर लीजिए सर।
सुन सकता हूँ।
सर आप वीडियो ऑन कर सकते हैं सर।
ओके सर, थैंक यू।
चलिए मैं भी रखता हूँ, मैं नीचे ही आ रहा हूँ बस।
ठीक है, आइए सर, आइए।